Hey Jordy, how you doing today?
Doing well, doing well. Where are you?
I am on Great Bear Road in Big White skiing this week,
Wow.
British Columbia.
You
And I
are,
have, as we're going to talk about it today, I have my bear beside me for the bear trustee discussion.
oh my goodness. And you're getting chirped in the chat, which I appreciate. Thank you. I can't be the only one who has to chirp. Um, but I guess this is what happens when you run out of clients, then you just go on vacation, eh, Ian?
Exactly.
Well, welcome
But I
everybody.
could I could miss this week's because of the excitement that was generated from last week.
Well, I'll put it this way: we seem to have thoroughly confused the majority of our participants last week, and so um, we will try to answer a bunch of the questions. We've had a whole bunch of questions, and we will answer them as we go. And we're going to just dig down a little deeper on the Bear Trust exemption or process to try to reduce probate tax and the first dealings exemption, and answer some questions and go from there. So we don't need to go on the background again because we're going to assume everyone was here last week. And so let's talk about the strategy about using a bear trustee as an owner, and when we're going to recommend it. And I know we touched on it briefly last week, but maybe because a bunch of the questions came in about that, and I'd like to just maybe refresh when we can discuss using a bear trust arrangement on real estate. Of course, the idea is that someone, either a corporation or a person, is going to be on title as the legal owner, but the beneficial ownership is going to remain in the original owner. That, in a nutshell, is a bear trust. So we talked about the value. Obviously, we got to keep that in perspective. The 1.5% tax, probate tax savings that we're trying to achieve, and is the real estate worth, is that number worth the headaches that we're going to go through to create a bear trust?
Yeah, and of course, a bear trust, the option of using a bear trust, as I said last week, is often seen in the development community because they don't want to know, they don't want to precisely identify who the purchaser is or who the owner is, so they might use a numbered company and sort of hide their identity in some respects, and that's part of the strategy that's sometimes used.
So on that point, we got a question about whether the trust disclosure rules, which have been postponed, were supposed to come in this year, have been postponed to next year. As far as I'm aware, there haven't been any clarifications on whether a bear trust is required to disclose the beneficial owners. Certainly, we've seen a change over the years of governments being more interested in beneficial ownership than they historically have been. Do you have any comments about that?
Yeah, no, it's for sure. I mean, look, ultimately, the new trust rules were brought in precisely for that reason, is that they're not going to allow us to use active trusts as a vehicle to hide the identity of the beneficial owners or the beneficiaries. But I agree. I'm not sure how they're going to manage the bear trust issue. That's something maybe the tax people know more about than I do.
As far as I know, we're still sort of waiting on clarifications on those issues. So that's another reason why, look, if, I mean, maybe in this case, we're not doing it for privacy purposes, but it's another, perhaps another hurdle that we have to jump through. We talked about the fact that the property, if they're about to sell it, in the next year, you might not go through all this, because the only way this works is if the original owner owns it when they die, right? It doesn't help otherwise. And the next two issues are really problems that the owner is going to have after it's transferred into a joint or into a bear trust, or at the time they're doing it. And the big one is a mortgage, right? So if you've got a mortgage registered against the property as the owner, and then you're going to transfer title, it's most likely that your mortgage, you're going to breach the terms of that mortgage, which say that if you try to transfer the ownership, the whole amount of the mortgage becomes due and payable. So that's an issue, right, Ian?
Yeah, and you see Bear Trust's arrangements set up with matrimonial, with principal residences, with some planners. And so if you go and you hold it and create your lending on the basis of your personal holding of the asset, and then you change it, yes, in fact, absolutely would trigger the banks to be very uncomfortable with the situation.
And what's usually recommended is you got to go to the bank and get their consent and, plead your case that, look, there's no change in beneficial owner. I look at this trust declaration and all of this, but they are not readily granting those consents. As when I talk to some of my real estate colleagues, some banks more than others. But so that's an issue as to when to recommend a Bear Trust if the property is subject to a current mortgage. And then there's the whole issue about what are you going to do with this land? Are you going to need it to, for further financing or future financing? Because again, now you go to the bank and say, oh yeah, I want to borrow take a collateral loan on my home and put a mortgage on it. And the bank's like, well, you're not on title. And so you have that problem as well. Have you run into that, Ian?
Yeah, and I think that, the key is really just this tool is, first of all, you don't see this tool being used a ton in estate planning. So we don't want to make it something that is overwhelming in terms of considering it in every one of your client situations. But secondly, it's not used a lot because of these very purposes and the very reasons that the banks are going to be uncomfortable with any changes. You're going to have to you're going to create all sorts of new layers of bureaucracy. So it better be done for the right reasons.
Yeah, and then the savings have got to be worth it, right? Like,
yeah.
In my view, just my personal 2 cents, like $1 million property, I'm not doing this. Like, unless I explain to them, but I'll mention it, but like this would not be something I'd be recommending at that level. It's got to be a significant amount here. So obviously the future use of this property is important. And somebody had a question about the principal residence exemption. In our material, there's this ruling, or at least the position of CRA, that transfer to a Bear Trust would not affect the principal residence exemption. So I point that out because there was a question about that. There's also this whole risk that CRA, which with this disclosure or the whole land registry system, changes their view on legal ownership, and the practice changes where people who are buying from a Bear Trust trustee are like, yeah, I'm not happy. I want to know who the real owner is, right? Do you see that possibly happening, Ian? Or
oh yeah, and look, and it's all also, it just comes down to not just CRA, but general disclosure obligations that are just ramping up more and more. It's one of the easiest ways to chase tax is to find out, get a better understanding as to who owns what, and that's where the trust laws disclosures changed, and it's a thin edge of the wedge. I think we're going down this route, but for the short term, it's a tool that as you say, if you die with it in this situation, it can be helpful for your planning.
So the other thing that came up a lot in the chat was, who should be the Bear trustee, and what are and by virtue of that, the problems that arise. So it's, a corporation is a Bear trustee. The benefit is that it never dies, right? And we'll see that as the problem with an individual, because in a moment. But there's also there may be requirements to file a nil tax return, because of course it doesn't own any asset legally or beneficially, and so there's really nothing on the balance sheet of a corporation that's a Bear trustee. But there are different schools of thought on that. Whether there's a tax return to be filed, et cetera. Do you see that a lot with corporations being as a Bear trustee? Certainly in developments, you see that, right? Development law.
That's where you see it the most, but they're transactional, right? but from a planning standpoint, you do see it if you want someone around at the back end, you do see this arrangement using corporate trustees as well.
And I've heard as far as, can you use an existing corporation or do you need to do a new corporation? This is not an asset of that corporation. So technically, it shouldn't have any effect whatsoever on the balance sheet of an existing corporation or anything else. But if you're going to sell that corporation or wind it up for some reason, or it's the bear trustee of this property, so you got to keep that in mind. And so often a fresh corporation, a clean corporation with nothing in it, is the recommended route.
Absolutely. And that's what I almost always, if you're going to do this, again, it ties to it's better be worth it because you're going to have to create a new corporation. You're going to have to monitor that corporation and so forth, attend to it corporately. Is it worth it? But I would not never, but you rarely see a situation if you're going to use this tool where it's got other assets.
Yeah. So the other option is a person, being the bear trustee. And the very problem that you're trying to avoid, which is that the owner is going to die and require probate, is the very problem that could arise by having a person on title. So, and Ian, I'm sure you've seen this, where they put a bear trustee person on title, they die, which then means that you need probate for their estate because the land registrar looks at it and this person owns it. And even if it has no value to the estate of the bear trustee, because they don't really own anything beneficially, it's still a problem. You got the same transmission problem that you've got if the real owner died.
Absolutely. That's why you rarely would put this in a situation like that. And not just why, there's also, of course, as you have identified, other aspects of the person not just dying, but being incapable or subject to creditors. And also just what are the terms of the bear trust? And then all of a sudden the dead person's estate says, oh, I wasn't a bear trust. It was actually gifted to me. And you create all sorts of potential hurdles where a plain bear trustee through corporate identification is probably the way to do it.
And we've done a whole webinar on joint ownership and the problems with that, and the bear holding it as a bear trustee. So if you think, oh, we're just skipping over that, it's very important. We have a whole webinar just on that very issue. But as a bear trustee, technically, again, you have no beneficial interest, so your creditors shouldn't be able to go after that property. But that's not going to stop them from going after that property, and you having to raise this trust declaration, say, I'm not really the owner, I'm just a bear trustee. And they're like, yeah, sure you are, and blah, blah, blah. So it can cause, for every solution, I often joke, we have a problem. And so that's the point there. I want to turn now, because we did discuss sort of the way you do use a bear trustee. And so we've talked about that before. Somebody asked the question about land transfer tax. There wouldn't be land transfer tax because there's no transfer of beneficial ownership. It's for nominal consideration. And there's a special affidavit and statement that says it's a transfer from beneficial owner to trustee. And we've attached the link for that guide on those. So land transfer tax is usually not something you have to worry about on that front. So I talked about using a second will to hold those assets, so we don't need to necessarily go into that again. Unless, Ian, did you have anything that you thought we should emphasize or reiterate?
No, I think that's good. I think we've wrestled to the ground the bear trust issue.
Okay, so we'll just spend a little more time on first dealing exemptions. So this is a very special rule that exists really only in Ontario, as far as I know. And again, this is where the property was purchased by the owner when the property was in the registry system, right? So that's when it was acquired. Like all property in Ontario, it's being converted from the registry system to the land title system. And so if that's the case, and there's been no disqualifying dealings with the property between the time the owner went on title and the death of the owner, then we have a piece of property that can be transferred without probate. Why? Because it uses the rules under the Registry Act, and the Registry Act never required probate to transfer. And that's the reason we have this. And so what they did is they grandfathered it. They said, look, you didn't, when you bought it, you were in the registry system, you didn't need probate to transfer it then, and we've converted it, so we're going to give you that exemption going forward. So those are the key elements. Now, the big question that we get all the time is, what disqualifies the first dealings property? So in other words, what things on title between the time the owner bought it and the time they die will say, oh no, that's now there's been already a dealing with it during the lifetime of the owner. So here are a few issues, and I'm going to list them and then tell you where I got these from. Discharges of mortgages, notices, leases, charges, so mortgages, survivorship applications, non-arm's length transfers for no consideration. So that's out of this bulletin. And this we will post as a blog on the state website. And this is from Mr. Lem, who is the registrar. And this is the statement that I rely on. So I didn't make this up. This is what I rely on. The issue there where there's some dispute is the non-arm's length transfers for nominal consideration. And then they give a couple of examples. The issue is, take this question, A buys the property in the registry system. It's converted from the registry system to land titles, and then A adds B as a joint owner. So now when A dies, when B dies, they're joint. So it goes back to A by right of survivorship. And then A dies. Can A still, because A was on title originally in the registry system, even though they added B on after the fact, are they still, can they still use the first dealing exemption? And I would argue that the answer is yes, because it's that transfer to joint ownership was a non-arm's length transfer for nominal consideration between spouses, A and B. Other people take the position that that is a dealing that now qualifies to basically say that was your first dealing. And so, Ian, have you come across this issue specifically, or is there still some? Okay.
So not on exact the facts. We tried to actually come very close to these facts, and we got an advanced ruling in our particular case now from the registrar. So the point is that and we got permission. So our facts were slightly different. They're not as clean as your illustration. So I just say that to remind everyone that we have that option of getting an advanced ruling on these from the registrar, so that if you are in that gray zone, it's an option anyway.
Yeah. And so before you sorry, Ian, go ahead.
No, but Rachel just pointed out, and it's a good point, that the land registrar doesn't permit, though, the registration of trusts or trustees on title.
100%. So that's the whole reason this works. You can't register anybody as a trustee. The land registry the land title system doesn't recognize trustees. That's why this works in a sense, because to everybody, to the land registrar, they look like legal and beneficial owners, even though that's not the case, right?
Exactly.
So before you go and transfer a converted property that's been converted from registry to land titles, before you add another person on title as a joint owner, for example, you may want to consider that issue and get a ruling on that. The reason I kind of think it's only fair that that it's allowed to do that is this statement that the land registrar, Mr. Lem, has said many times, that if you buy in registry, you get to die in registry. And so the idea is that A bought in registry, A died and gets to die in registry, whether they put someone else on title in the interim, as long as they stayed on title through the whole period. So anyway, that's my 2 cents on that. Then we had a couple of questions. So these other dealings don't disqualify, pretty clearly don't disqualify the land from a first dealing exemption. So we talked a little bit about how you sort of determine this, and this was the example that I showed. You're looking for a few items here. You're looking for the fact that it is land titles conversion. So someone asked us, condos. I mean, as far as I know, and I'm not a real estate lawyer, but I've never seen a condo that wasn't in the land title system. I don't think it can be. So so condos are not going to be a subject to a first dealings exemption, as far as I know. Ian, have you ever come across a?
Never.
No. So so you're going to check, obviously, the name of the owner at the date of death is the same as the owner when they went on title, and they haven't transferred it out of their names, and the date of conversion to land titles is after they bought it, after they went on title. So that's really what you're looking for. So I don't know if there were any other questions. Let me just see if there were any other questions about this issue. And before we because we talked about multiple wills a lot. So there was some discussion. We talked about sort of who you pick and the risk of a successor, the bear trustee dying. And really there's not a lot you can do about a successor. I guess you could appoint them as a joint, as if they were on title with the, you had 2 bear trustees in essence by right of survivorship. If one died, the other one would, technically still be the bear trustee and could deal with it that way. Is that, what do you think?
I guess that's probably the only way you could do it. But yeah, because I don't know how else you'd do it. I don't know. That's a good question.
I think, yeah, I think you'd have problems, because that sole, again, if you're using a person and they die, land title, you can't have it both ways. Land titles is looking at the owner, right? And they're going to say this person died, and you're like, what? They're a trustee, and as Rachel pointed out, and which we should have pointed out, they don't care about trustees. They don't think about trusts. Trusts aren't allowed, in a sense, under the land title. That's really the issue. So we've sort of talked, and a bunch of the questions had to deal with that. So we wanted to make sure that we address that. Let me just see if there were any other issues that that we wanted to talk about.
Just in the chat.
Yeah, I'm just looking at the chat right now. Yeah, there was an issue about different assets, and this is really important for us to understand why we need a secondary will. If you had only one, if you knew that the deceased was going to die with only one property that would qualify as a first dealing, then and you don't need that will for any other purpose. They don't own any other assets, right? Okay, then you could go with a single will, because the will that you won't need it to probate. You won't need to probate it to deal with that land, and it's the only asset that the deceased owns, so you're okay. But that's often not the case, right? Often the case is that the deceased owns a property that doesn't need probate and other assets that do need probate, and that's why you need a secondary will. So we can't really emphasize that enough. You cannot pick and choose when you probate a will as to what assets you're going to say this needs probate or this doesn't. Once you've got one will being submitted, you gotta pay probate tax on it, on all assets covered by that will. And otherwise we wouldn't need secondary wills. So I just want to, there's been a bunch of questions about that. You can, sure, you don't need probate to deal with that land, but you're still going to pay probate tax if that land is covered by the will that you submit for probate. So the another question, this goes to the first dealings issue, and again comes to this question: what happens if two people, A and B own it in registry, and then it's converted and A and B transfer it to just A. Does that qualify? I am definitely not giving an opinion on that. You can go to that bulletin that I showed you. You could say, look, this is this is a non-arm's length transfer for no consideration. But I would get a ruling on that. Now, I would continue to rely on this theory, which is if you buy in registry, which A and B did, and then A transfers it, or A and B transfer it to just A, well, then you're still in registry. On the other side, you could say, well, there's been a transfer, so they, but again, that's really the issue, and I don't think there's a definitive answer. I've actually reached out to Mr. Lem on this, and if I get an opportunity to run some of these by him, I will report back on this. An intestacy, we can't deal with you can't deal with land on an intestacy under the first dealing exemption. Okay. The reason it works is because under the Registry Act, where there was a will, you did not need probate of that will. You could rely just on the will itself. If you were in an intestacy, you're going to be paying probate tax on even first dealings property. Another reason to get a will. Ian, I hope that we've answered all of the questions, at least that were more general. There were some that were very specific, and I don't think we're able to answer that here. Anything else?
No, I wouldn't. We did one of the questions was just in terms of process, and people should know that these are recorded, of course, every week and are available on the eState website.
Yeah.
So if you did come in this week and you didn't catch last week's, you can get it there.
Yeah, for sure.
And if you have any trouble finding it, just let us know.
You bet. Well, thanks, Ian. I hope that we answered. We left people less confused at the end of session 2. It's again, as you said quite rightly, it's not an everyday occurrence using Bear trustees, but it's something to know that we have in our toolkit and to discuss. So
yeah,
thanks.
No, and I think that's right. And that's why I don't want to get overwhelmed. People shouldn't be overwhelmed by it. It's just it's a rare option. But if the second part of the conversion is an issue that we always have to keep top of mind.
Thanks, everybody. And thanks, Ian. Hope to see you guys again next week. Ski safely.
Thanks.
Okay. Bye, everyone.